What's up, everybody, and welcome back to another episode of Lockdown 23-1. If you happen to be new to the channel, first and foremost, welcome. Hit that like, subscribe, notification bell if you enjoy. We talk about all things lockup related. And today we're going back to the courtroom. Word is the oil truck is backed up at the courthouse, ready to lather the boots up for a good old smoke fest. 65-year-old Jenny Norris was shot standing outside of her home on August 7, 2021. Witnesses told police a black vehicle circled the block multiple times before shooting, and then as the vehicle came around the final time, someone inside fired 8 shots before driving away. 23-year-old Terrell Lipkins was charged and his trial began March 15, 2022. The jury reached a verdict on March 17th and he was found guilty of all charges. Blood and Lipkins was released from prison in early 2021. After doing time for the same exact felonious assault, which is a drive-by. That's why they were circling around the block so many times, probably trying to wait for the dude to come out. And he does, and he happens to go outside and talk to Miss Jenny Norris. And even though the bullets weren't meant for her, she's the one that ended up getting hit. She was pronounced dead at the hospital. I can't even begin to tell you how many stories I've done where drive-bys went wrong. But like I said, Mr. Lipkin was found guilty in just 2 days by the jury, and today we're going to see him get sentenced.
Before we start to go to the sentencing, the court did find the defendant guilty of carrying a concealed weapon, and I don't know weapon under disability, and I don't know whether the party stipulated to that or not, but now that I have both these entries in front of me, I'm confident in that finding and still would stand by that finding.
I do apologize, Your Honor, but it is necessary that we do this courtroom analysis. Let's go ahead and start this off strong with the long neck green lamps. Handcrafted in 1910 in the Jumanji Shoe Factory. Let's just face it, okay, it ain't no courtroom unless you got a long neck green lamp like that. And what better way to complement the long neck green lamps than a long neck antibacterial bottle? And let's not forget about the judge's great choice in suits. Shit.
Consider that for opening the state's case. Before we do the sentencing, is there anything, I'll start with with the defense, is there anything you would like to, I know you did a sentencing memo, is there anything that you would like to say on your client's behalf or put forward before the court?
You know, other than what I stated in my sentencing memo.
Damn, is that another judge behind him? Imagine getting smoke from the front and back. This courtroom's built different. They got the mega clock in the back, knowing damn well you ain't never gonna care about that no more. Where you're going, it's all gonna become one day.
I know you did a sentencing memo. Is there anything that you would like to say on your client's behalf?
You know, other than what I stated in my sentencing memorandum, we're looking at an indefinite prison term here of at least 15 to life. I believe that would adequately punish the defendant. I would ask that all other sentencings be ran concurrent with that, and ask that the RDO not be imposed, and that the applicable mergers be done along with the gun specifications that should mergers on, as I stated in my memorandum.
Sure.
All right, so I don't know if y'all could hear that too good. The audio is a little rough, but he was asking, I believe, for 15 to life and for all the charges to be ran concurrent. Will he get it?
Anything else from the defense?
No, Your Honor.
Okay, we'll go to the state of Ohio. Is there anything that you'd like to put on the record, or is there any family member or anyone who wants to make a statement before I go to sentencing?
Yes, Your Honor, there are a couple family members. And just for the record, I know that the court allowed Mr. Kowalczyk to speak, but I want to make it clear that Mr. Lipkins has had an opportunity to speak as a client. Is that correct, Mr. Kowalczyk?
For appellate purposes, I have advised him not to speak.
Thank you. The first, Your Honor, would be Jenny Jones.
My name is Jenny Bell Jones. I am the firstborn and oldest daughter of Jenny Bell Norris.
Okay. I appreciate you coming here today. Please feel free to go ahead and just speak slow enough and loud enough so we can get it down, okay?
Okay.
Thank you.
Damn, poor Jenny.
As I sit and think every day of how to get me and our family through this awful, unnecessary tragedy, I just keep coming up with the same answer. what would our mother Jenny say or do? I think she would tell me,
Smoke 'em.
everything happens for a reason, and the love and the closeness within our family will grow stronger as we rely on each other to try to heal the pain of the daily memory of this tragedy that will forever be a scar within our lives. Our mother would always be there for each and every one of us when we needed her. No matter if the situation was good or bad, she was always there to support her family. Through weddings, funerals, childbirth, sickness, broken bones, surgeries, divorces, baby showers, graduation,
Oh, man.
Christmases, and hundreds of birthdays.
Jenny's about to
Just
get me.
everything. She was always there.
Damn.
She did whatever needed to be done in order to make sure our family was taken care of. This tragedy is only one of many types of situations that we would turn to our mother for comfort, guidance, support, and love. But our family cannot do that now.
Damn, man.
Thank you, Your Honor. And I just want to make the record clear, Your Honor, and I know the court's aware of this, but I want the appellate court to be aware of this, that on December 15, 2016, Mr. Lipkins was convicted of felonious assault, a felony. He received a sentence of 4 years. He was released early on judicial release on that sentence. That judicial release was eventually revoked. He was sent to prison. On July 22nd of 2019, he was convicted of intimidation of a witness and aggravated menacing. He went to prison for 9 months on that. On November 2nd of 2020, he was convicted of 2 counts of felonious assault and tampering with evidence. On January 29th of 2021, having been sentenced to prison on those convictions, he was released on judicial release. 7 months later, Mr. Lipkins committed this offense. And as a result of his actions, this world has lost Jenny Norris, who we know now was a grandmother, a mother, and a great-grandmother who was loved by many people. And we lost her for no reason. For that reason, I know this court will impose the appropriate sentence. Thank you.
Thank you. Anything else from either counsel? Before I get started, the Norris family, I mean, you have my deepest sympathies. I've heard so much about your mother and grandmother, that she was like the mom of the neighborhood. Made
Looks like homeboy's a bit chilly. Warming them hands up to hold them coals. It's about to get smoky.
cookies for people and looked out for everybody. And it's just sad that she didn't get to enjoy her retirement, and even more tragic that she's not here today with you. Sentencing is very unique in Ohio, and as I indicated, this is probably one of the most confusing ones because of the way the legislature has designed crimes. You may hear some terms that you may not be familiar with. I'm going to walk through it very slowly, and I then will also do a little summary for you so you walk out of here not confused, but have a pretty good idea of where the court went with and why the court did what it did, okay? The count of murder it's what's called an unclassified felony. It carries a sentence of 15 to life. The court doesn't have any discretion on that, and the court will sentence you to 15 to life.
Okay.
I do have a few words that I want to say to Mr. Lipkins.
He made it snappy, didn't he?
You've chosen a life of crime and intimidation. I can't understand why a 23-year-old would want to literally throw... Look at me when I talk to you. Don't you look away. Why you would want to throw your life away. for this kind of
Damn.
conduct. That makes absolutely no sense to me. I'm tired of the bullets. I'm tired of the deaths. I'm tired of neighbors living in fear just outside their door because people like you have no regard for human life. I don't know why, and I see young people here, and I've watched people throughout the trial. I can't comprehend why you don't pick up a book. Read a book. A book has knowledge. These guns are doing nothing but it's a road to prison.
Yep.
And it's going to be a long road for you. I don't believe that you can be rehabilitated. You've demonstrated a pattern of no regard for human life. Your prior imprisonment terms have not taught you anything. When another judge let you out early, you went back to your life of crime.
Yep.
I am so incensed when I got this case, and I have now found out that you were in a prior drive-by shooting, not even a year prior to this crime.
He ain't learned shit, Your Honor.
I mean, this has to stop, and I'm going to make sure with you that it stops today.
It ain't gonna stop.
So the
though, Your
murder
Honor.
charge, I'm going to sentence you to 15 to life for the death of Jenny Norris. It's an unclassified felony. I will run any of that time. Again, there's two separate cases. This is case number 2021 CR 1715A. So that sentence will run concurrently with case number 2021 CR 2188A, which I'll discuss later. With that murder charge, ladies and gentlemen, it carries a 3-year mandatory gun specification, which I have ordered. There's also a firearm specification of 5 years, which I will be ordering. There's what's called a repeat violator offender specification, that if the state proves that he's a repeat violator offender, which Mr. Barr put that information on the record, and I have found that, the court can give a sentence on that from 1 to 10 years. The court in this case is imposing 10 years. Count 2 on the felonious assault of Jenny, it merges into count 1 because the felonious assault merges into the murder. There's case law on that, and the court has to follow the law.
All right.
However, it's very confusing with these gun specifications, but I do believe, even though that merges under State v. Davidson, that the court shall order the mandatory 3-year firearm specification on that count. I think having weapons under disability, they tried that case to me in the states by forwarding me the prior convictions. He couldn't do it to the jury because it could prejudice the jury, so it was done now. It carries a maximum of 36 months prison, and this is what's called a definite sentence, and the court will sentence 36 months. There's also discharge of a firearm on or near prohibited premises. The law there was somewhat contradictory, but the court finds that it can sentence 36 months, which is the maximum on that count. That carries with it a 3-year mandatory specification for firearms and a 5-year specification for the drive-by shooting.
God, he's getting specced up left and right.
The improper handling firearms in a motor vehicle merges with the murder as to the second count of improper handling firearms in a motor vehicle.
This dude's burying them.
Now, all these cases, all these counts will run consecutively. So to make it a little easier, on case number 2021 CR 1750A, Bennett will serve right off the bat 21 years for all of those specifications prior to the sentence even begins on any of the other counts.
Wow.
There will also be a sentence of 15 years to life on murder on top of that. Then there will be 72 months, which is 6 years, 36 months on each count of the felonies of the 3rd degree, weapons under disability, and the discharge of a firearm on or near the premises. So that's what I have on the first case. We will now go to the second case, which is 2021 CR 218A, where Mr. Harvey and Mr. Tolbert were the victims in the case. The court will order 8 years on the felonious assault. It'll be consecutive to count 2, and it'll also be consecutive to the prior case, 2021 CR 1715A.
Just say everything consecutive,
The
Your
court
Honor.
will order the mandatory 3-year firearm specification. The court will order the 5-year specification for drive-by shooting. And the court will order 2 years on the repeat violator offender specification. On count 2, the second felonious assault for Cortez Tolbert, the court will order the maximum of 8 years in prison. That will be consecutive to count 1 and also consecutive to the prior case number 2021
Longest
CR
Chattanooga train
1715A.
smoke.
The court will also order,
Just keep on
and
hitting
under
them.
State v. Davidson, the 3-year firearm specification. However, the court does find that the specification for the violent offender and firearm specification under that count, both of those merge. Now, this is what's called Reagan-Tokes, and it's confusing. On the felonious assaults of 8 years, he will have what's called a 16-year minimum sentence and a 20-year maximum sentence, because
How
they're
much
called
is all
indefinite
this?
sentences. And again, at the end, I will try to lay this out for you a little simpler.
Okay, thanks.
The
Thanks,
minimum
sir.
sentence on those counts would be the presumed date he would be released from prison. The Department of Rehabilitation could rebut this presumption and continue his incarceration based on his behavior in prison,
Nobody likes
any
rebuttals.
infractions or threatening of harm to others, being placed in restrictive housing, classified as a security level 3, 4, or 5. They could only rebut this by having a hearing, and if one of 4 of those could apply. They could also reduce that portion of the sentence by 5 to 15% if the defendant did what he should do out there and notified the court. The court would set a hearing, notify the prosecuting attorney and the victim, and report its findings to the department within 60 days. The court would take into consideration the 4 factors the DRC considers: whether the defendant was in a rehabilitative program or activities, or would not be residing in a halfway house, reentry center, or community residential center, or did not have a fixed address, could even begin the sentence. So on this second case, he'll have 13-year gun specifications before he would even begin the sentence of a minimum of 16 years to a maximum of 20 years. Now, I know this can all sound a bit confusing, and it's confusing for judges and it's confusing for lawyers. But I did try to do some math for the family so that you walk out of here gain some kind of understanding of where we went today.
Yeah.
And what I have calculated is he will be serving 71 years to life as a minimum sentence.
But that's it. Another one for the record books, ladies and gentlemen. If you enjoyed, don't forget to hit that like, subscribe, notification bell before you leave.